We'll talk to you a little bit about when you get this body of evidence, what you've got right there is this is the rough outline. Now you have a rough outline of your story. You know, Jerry is going to talk to you later this morning. Jerry's the first guy I ever heard say it's all about storytelling. Jerry recognized it before the rest of us did. And you got some brilliant people talking to you today. It starts right after I finish. But you've got the outlines of your story. You got the rough outlines of what your story is all about. But then you want to look at your story. I'm going to mention, I don't have time to talk about storytelling except to say this. Look at your story from the first person version of every witness. Instead of looking at what a witness says, write out that witness's version of what happened from the first person, as if you are in that person's position. Write his or her story in the first person as if you are that person. It gives you a perspective that you won't get looking at it from the outside. This is what this witness is going to say. I'm viewing you as a third person. No, I want to be in your position. So if you want to get an insight into the story, try to write your story, just try to write it out for your own benefit in terms of, I am the first person, I'm telling the story. Now, in an ideal world, you got the accident, the auto accident took place, you would then go to the corner where that witness was standing when he saw the accident, you would stand where he stood, you would then have his story in the first person, you would see what he could actually see, you could see what he couldn't see, and you would learn a lot more about the other things that he might have added to his story, might know additionally. In an ideal world, you can do that. Now, when you start then thinking in terms of putting these together, the first of the principles I want to talk to you about, the psychological principles, is a tremendous opportunity for us as the plaintiffs to use. It's the availability principle. And the availability principle tells us that the jury will focus in the jury room and the deliberations. They will focus on where you place the spotlight during your presentation. They will focus on what you make available to them, what you choose to make available to them. Now, if you choose to make available to them, you spend your entire case talking about your plaintiff. That's all they have available to them. All they're going to be examining when they get in the jury room is your plaintiff. So the availability bias is critical because we can use it. We're first. We get to decide what we want to make available to the jury. And I call it the spotlight theory. We get to decide where we want to put the spotlight. And as a general proposition, you want to put the spotlight on the negligent conduct of the defendant and the damages of the plaintiff. Now, it is not enough today to try a case in which you simply prove the negligence of the defendant. I submit to you that you have to go further and prove the absence of negligence of your plaintiff. Prove that your plaintiff did the right thing. It's the norm bias. What do you compare it to? Compared to what? Think in terms of compared to what. Okay. The plaintiff's conduct is right compared to rules of the road, compared to what is expected of drivers, compared to what is expected of whatever your plaintiff is. My plaintiff acted properly. My plaintiff did everything right. So the reason is you can't just leave it out there that, okay, the defendant was negligent. That's not enough because there's an anti-plaintiff bias. So if you don't come in and say and show them that my plaintiff did everything right, they will make up stories about what your plaintiff probably did. Well, he probably did this or he probably did that. Trust me, we see it over and over and over in focus groups. So take that extra step and prove that what your plaintiff did was the proper thing to do. They met the norm. Okay? Now, I want to bring up the next of the principles after availability is something very important because we lose a lot of cases on causation. So I want to talk to you about the attribution principles. And the attribution principles are these. It is, what are the principles that jurors use in attributing responsibility or attributing fault, if you will, for conduct? Now, there's a friend of Dave's named Lee Ross, who's a professor at Stanford. And Lee actually has come and spoken at Dave's invitation. He's spoken to at conferences in the past. And Lee came up with the fundamental attribution error. What he discerned was that in placing responsibility, in placing fault, jurors will look at basically they look at three things, but basically two. They'll look at people involved, and they'll look at circumstances, and then they may or may not look at timing, and there's things surrounding timing and so forth, but that's usually not relevant. So basically it comes down to situation versus people in determining what is the reason that this occurred. What is the fault? How is fault placed? They decide, was it people that caused it? Or were it circumstances? Were the circumstances the cause? Here's the error. What Lee says is that the fundamental error is that jurors will err on the side of overemphasizing the situation as being causative and underemphasizing people as being causative. So what we have to do with that is this. They're going to, I'm sorry, I got that exactly backwards. They will overemphasize the conduct of people and underemphasize the situation. What that means is this. If they look at people as being causative, when they're trying to decide what caused something, who's the person they're looking at? They're looking at the plaintiff. So you've got the plaintiff injured in an accident or some type of tragedy, and they look at it and they're saying, okay, did this injury occur as a result of people, the person involved, that is the plaintiff, or did this occur as a result of the situation? They will overemphasize fault on the person, underemphasize fault on the situation. Two ways to use this. The first thing is, remember, you got two people involved. It's okay for them to overemphasize fault on the person so long as the person is the defendant. Now, in looking at whether they're going to place fault on the person, they will look at the individual traits and characteristics of the person. This comes back to another fundamental concept, which is liking the plaintiff, the concept of liking. It is very important that the jury like your plaintiff. It's important that the jury like you. But this is one of the reasons. So when we're talking about our plaintiff, we have to set up the plaintiff not just as an injured party, not just as someone with all these devastating injuries. We have to talk about our plaintiff in terms of their responsibility. They're a responsible person. They're a responsible driver. They're an experienced driver. Whatever it is they're doing, they are good at this. They take responsibility for what they do. They have a lot of experience as a driver. You bring out traits that would make a jury believe that as between the plaintiff and the defendant, the person most likely to have been causative here is going to be the defendant. Because going in, and this is the error part, and this is part of subliminal jury bias. This isn't something that the defense created. This isn't something the insurance industry created. This is just out there. This is just a psychological principle that's out there that works against us. Just fundamentally, they're going to look at the person and say, "Gee, you got hurt in an automobile accident? Probably your fault." Okay, so you need to always be building up your plaintiff in terms of their character, their experience, they're doing the right thing, and then attacking the defense on the other side. And this is where the next error comes in, which the next attribution comes in, which is the purposive attribution theory. There's purposive, reactive, fundamental, defensive. There's several of them, but the ones that I want to talk to you about, purposive attribution. Purposive attribution is this. The jury will be very hard on someone that they feel attributed to causation as a result of acting on purpose. Now, on purpose, not intentional. We're not talking about intentional willful conduct. We're just acting on purpose. Someone is driving 70 miles an hour in a 40-mile zone. They are driving 70 miles an hour on purpose, not willfully to injure a plaintiff. They're driving 70 miles an hour because they chose to. They're acting on purpose. Now, the more purpose you can show, the more purposive conduct you can show on the defendant, there gets to be an irritation factor in there. So this comes back into the thing that I worked on a lot, which is choice, the power of choice. I think choice is one of the 2 or 3 most important words we can use in the courtroom these days, honestly. If you show that the defendant chose to act in the way they're acting, the more choices you could show that the defendant could have made that would have avoided the result, the tragedy, the better off you are, the stronger your case is, the irritation factor there kicks in big time. Now, you take a medical negligence case. You show that a doctor had 2 choices. He chose this one over this one. As a result of this one, there's a tragedy. He could have done it this way, and maybe there wouldn't have been a tragedy. That's probably not going to get you there in a medical negligence case, because he's going to come in with all of his friends and expert witnesses who are going to say, no, either one was fine. This is just one of those things that happens, and it wasn't negligence. But here's what you can do. You show that there were 5 different choices. When the patient came in for their evaluation by the doctor, there are 5 different tests the doctor could have. There are 4 tests the doctor could have done. This is an actual case I tried. There are 4 different tests that the doctor could have done. Any one of those 4 tests would have caused the patient to be hospitalized overnight. They could have done this, in which case, ladies and gentlemen, we wouldn't be here. He could have done this test, in which case this would have been found, and we wouldn't be here today. He could have done the same thing, 3, 4. Instead, the doctor chose to send the patient home, where he died in his sleep during the night. So the more choices you can show that the defendant had, which could have avoided the result that you have here, the stronger your case. And it even gets to the point where if you get enough, it gets to the point of being almost willful.